Can you hear me now? Super. Good afternoon, everybody. It's lovely. Well, I can't actually see you all, but it's lovely to be with you again. This afternoon, we're going to have a chat about flexible working, just because we know that the HR landscape is changing. We know the way that we're working is changing, and it's really important that we remind ourselves of what our obligations are and have a look at what some of the challenges might be going forward with flexible working. So traditional position, as we know, is that we have in the past believed that productivity depends on set hours in an office environment. When I was coming through the ranks, it was always sort of, if a bum's not on a seat, we don't know what they're doing, and therefore, there's some paranoia around whether people are actually working or not. The pandemic obviously has caused a lot of loss, a lot of difficulty and substantial challenges, but with the lockdown from the 16th to the 23rd of March, everything changed for all of us because effectively we were all working where we could from home. We had businesses locked down, we had schools locked down, and effectively people's home became their workplace. That, in my view, is a decision that's probably going to affect the way that we work forever. As the lockdown is now easing, we've got some people returning to work, having had a period of time working from home, or there have been other adjustments to their working patterns. And I think there's going to be a lot of employees who are going to be keen to try and maintain that flexibility, maybe because they've got concerns about coming back into the workplace with COVID still around, but also because they've actually found a new way of working that is both beneficial to the company, but also very beneficial to them. As a result of that, I think there's going to be a real likelihood that companies are going to see a substantial increase in flexible working applications going forward. So what are the benefits of home and flexible working? So we know there's been an increase in any event in home working over the last few years. The Office of National Statistics confirmed that around 5.1% of the working population, so that's 1.7 million people, in the main worked from their home during 2019, whereas that was only 4.3% in 2015. It's likely that COVID-19 will substantially increase those figures, and it'll be interesting to see where we are in 2 years' time and what that percentage actually is. It's also the case that flexible working now seems to be the main motivator for work rather than money, and that historically traditionally money has, but with the YGen and their way of working, and also now the impact of COVID-19, it seems that flexible working is the biggest motivator, mainly because you can achieve a better work-life balance. You haven't got to do the commute every day. My commute, for example, is 2 hours, and if I'm not in the car for 2 hours, I can certainly be more effective in terms of what I'm doing. There's a reduction in stress. The stresses and strains of, everyday life, trying to get the children ready, trying to do this, trying to do that, trying to walk the dog and get everything done before you have to get in the car and go to work. And then all of a sudden that stress is relieved because you can work in a different way and everything's at your fingertips in terms of your personal life as well as your work life. Mental health also a big factor here. I think it's the case that people working from home, possibly two camps. Those that have been working in isolation may well have struggled. However, I think overall, people's well-being has improved, and therefore that overall improves their mental health. So there's lots and lots of benefits in that respect. And I think if you're a company that's going to be open to flexible working, it's really clear that you're going to be able to retain your staff. If you're not going to move with the movement that's now happening, you're probably going to lose people that are going to move to organisations that are willing to embrace flexible working. The other thing is that having had to put this in place because it was enforced on us by the pandemic and of course the government, companies are now realising that actually productivity is increased rather than decreased from home working. So all of a sudden they're realising that all that mistrust and perhaps difficulties that might have been posed by trying to set people up to work from home has actually been removed because we had to do it. Given that the government's instruction remains that where you can work from home, you must continue to do so, it looks as if there's no immediate change in sight, and we may be left with this perhaps for the next sort of 18 months, maybe to 2 years, very much depending on where we are with the vaccine. Of course, as well as providing better work-life balance and benefits for employees, there are wider benefits. Firstly, companies, and no company is different in this respect, all the calls that I'm getting are around looking at them rethinking their current spaces. So if you've got expensive office space but you realise that there's a different way of working with employees either partially or fully working from home, that could free up a lot of cash for a company that perhaps is struggling in terms of rents. It's also good for the environment. You know, we had Boris in Dudley the other day telling us about how pollution and the environment was a top priority for him. If we're not driving to work every day, there's a real reduction in pollution. I think we've all seen that over the last few months. So there are those wider benefits as well. What's happening in the media? I'm sure you've all been keeping abreast of it. There was a BBC article on the 22nd of May that said that flexible working is likely to be the norm. Lots of employers are coming out of lockdown and looking at new ways of working. Facebook, for example, has confirmed that half of its workers, of which there are many, will work remotely in the next 5 to 10 years. Twitter has confirmed that employees can work from home forever if they want to do so. Amazon have also confirmed that staff have the option to work from home until October. Obviously, those that are not on the packing line. Barclays have currently got 70,000 staff working from home. And the Barclays boss has said that the big city office may be a thing of the past. Google's extended its working from home policy until the end of the year, and Royal Bank of Scotland have stated that staff will be allowed to work from home until at least the end of September. So all the big guys out there are all realising what the benefits are, and they're starting to adjust, but actually also opening up to what are the possibilities going to be once this is fully restricted and we haven't got the difficulties of COVID going forward. So what do employees report about their top 3 most common benefits from working from home and how they want to work from home? So the traditional way of having flexible working, of course, has always been part-time working, very much public sector, but sometimes in the private sector there's flexi-time working that's operated. And of course there's working from home, which we've all been doing. Let's have a little recap of the law before we turn on to some of what the issues might be going forward. So we know that since 2014, all employees who've got 26 weeks continuous service can make a request to work flexibly. Excludes agency and workers and shareholders in certain circumstances, and I'll come onto that in a second. It is the case that an employee can only make one request in a 12-month period, and there's nothing to prevent parties agreeing a trial period. There's nothing in the legislation that refers to trial periods, but there's no reason why parties can't agree to do that. The application form from the employee has to meet the statutory criteria. And of course, there's a 3-month decision period from the receipt of the request to when you need to complete the process. That 3 months needs to deal with, therefore, the initial part of the process and any appeal if there is one. But that period can be extended if the parties agree that it can be extended. Just remember, throughout any flexible working procedure, the right of accompaniment applies, and that should be offered to the employee at all meetings. A request, of course, can only be made by an employee, and it's important to remember that because obviously you may be getting requests from other individuals who you engage, and only employees are able to take advantage, therefore, of this statutory right. So for the purposes of the Employment Rights Act, an employee is an individual who's entered into or works under, or where the employment has ceased, worked under a contract of employment. Subject to meeting other criteria, fixed-term employees and those employees who already work under a flexible pattern can also have the right to make an application. It doesn't apply to self-employed contractors, consultants, or, as I've said, agency workers. What kind of request can be made? So an eligible employee may request a change to their employment terms if it relates to a change to their hours, a change to the times that they work, or a change to the place that they work. And I think it's the place that they work, possibly with the times that they work, are going to be the 2 main sort of applications that are made going forward. What about informal requests? Now, we all know that informal requests can actually be quite dangerous. Have we all had that situation where somebody's spoken to the line manager, but HR don't know anything about it, and the line manager said, yeah, you can come back 3 days a week, that's no problem at all, having no regard whatsoever as to whether that actually meets the needs of the business, and therefore causes you difficulty. Informal requests can be made, remember, by people who don't have the requisite length of service. So if you have somebody got less than 20 minutes chat to that manager, that situation is not a formal statutory request, but of course it will be an informal request. And even though it's not part of the statutory request and therefore they don't have the right to hold you to any decision that's made, there is a potential implication with discrimination claims if you then withdraw that agreement that's been reached. So it's really important to make sure that you, if you can, ensure that your managers understand and those above that it's really important to go through the proper processes every time a request is made, even if it is potentially for somebody who's got less than 26 weeks service. So, triggering the process. The employee triggers the process by making a written request. You have the 3-month decision period, which we've heard about, to notify them of the outcome and deal with any appeal. The application must be dealt with in a reasonable manner. And remember, there's no definition of what's reasonable. You can only refuse a request for 1 or more of the 8 business grounds that are cited. And what about the request? In order to comply with the statutory criteria, the application has to be in writing, be dated, vital point, because very often you might get a request that isn't dated. State that it's an application under the statutory procedure, specify the change that the employee is seeking and when they wish that change to take effect. And most importantly, the application has to explain what effect the employee thinks the change will have on the employer and how that could be dealt with by the employer. And that tends to be, if you haven't got a pro forma, the one thing that employees will miss out. It also tends to be the thing that's missed out if there's an informal request that's been made either by somebody with less than 26 or more than 26 weeks service. It also needs to state whether or not the employee's made an application previously. That process, and the formal process in terms of the 3-month time limit, does not start until you've got a properly formulated application. So if any of those points are missing from the list that I just gave you, until they've rectified that, you are not bound to start the 3-month time limit to deal with the process. What about requesting temporary changes? Again, there is nothing in the legislation about requesting a temporary change, but I've put this in today because I think it may well be that even if you don't get flexible working applications that are around permanent changes, because of course they are a permanent change to terms and conditions, you may well get them for temporary periods, especially, for example, if you've got the kids still off from school, it doesn't go as well as they anticipate with the return to school in September, things change again. It might be that you're looking for a temporary arrangement in terms of that change to your terms and conditions. And I think in that situation, you also need to be open, even though it's no statutory requirement to do it, open to dealing with temporary flexible working requests. The ACAS guide suggests that where the employee is looking for an informal change for a short period, such as would apply now because of the children being off, that you should try to consider it and agree to it wherever possible. So how do you deal with the request? You must deal with it in a reasonable manner, as we've said, and notify the employee of your decision within 3 months. But what is a reasonable manner? There's no statutory definition, as I've said to you, of what it means to deal with the request in a reasonable manner. The ACAS guide and the code make recommendations on how an employer should deal with an employee's request for flexible working, and that gives you that guide around whether or not this would be deemed reasonable or not by the tribunal. So firstly, discuss the request with the employee. Well, if you're following the proper process, and although the process doesn't say you've got to have a meeting in the prescribed way that it used to, you do then have a meeting with the employee, you're going to be reasonably listening to what they've got to say in order to deal with the request. Allowing them to be accompanied, obviously that's reasonable, it's a statutory right. Arrange appropriate venues for the meetings. Make sure it can be, a meeting that takes place at the right time for that individual and in the right place. And take a considered approach to the request and the decision that's issued. So let's say we're going to hold the meeting. Once the request has been made, you need to invite the employee to the flexible working meeting and offer that right of accompaniment. As I've said, have regard to when the meetings can be held, taking into account, people may be working part-time, or they may have other appointments or other commitments, and making sure that that is a reasonable time to expect them to attend. We know what the right of accompaniment is. They can be accompanied by either a fellow worker or a trade union representative, but you may want to extend that should there be certain circumstances, and of course that may be considered a reasonable adjustment. In some cases, you might want to actually agree to the request without a meeting, in which case you need to write to the employee and confirm the decision. It's always dangerous, I think, to move away from the statutory process, but if it's an obvious request that actually the company can accept, then there's no problem in you simply just saying, we've received your application and we're going to accept it, and here's the letter to confirm what the changes are. If you are having a meeting, though, use that meeting to discuss what the employee is proposing in detail. They need to have an opportunity to provide an explanation about all of the points that they've put in their application. And most importantly, you're going to want to drill down on that question around how can we accommodate the request that you're asking for. If you can't accommodate the arrangement, then you also need to explore potentially what alternatives there could be. So it might be the case that at that meeting it's not appropriate to do so, but you come away from that meeting and have discussions with the line manager or others in the organisation, and you actually say, well, there's an opportunity here for us not to accept what they're putting forward, but to put forward an alternative proposal. Again, there's nothing in the legislation about that, but it's open to you to do that, to try and reach agreement with the employee. Once you have completed the meeting, you then need to write to the employee to confirm what the decision is. Now, trial periods. As I've said to you before, there's nothing in the legislation about trial periods. However, it doesn't prevent the employees from agreeing one. And they may be an advantage to both parties. It might well be that you trial a particular arrangement for 3 months, and after that 3-month period, it becomes clear that it is feasible and therefore can turn into a permanent change to terms and conditions. If you're going to grant the request and you've written to the employee to confirm it, that new work pattern will be a permanent contractual variation to the employee's employment. That means, and I think people probably think of this of, oh, well, I've just issued them with a written decision, but actually you have to issue what's called a Section 4 statement. And that's a written statement of the changes to the employee's terms and conditions. And that has to be issued to the employee within 1 month of the changes taking effect. It's likely that you would issue it to the employee immediately, but you must issue it within that 1 month period. It's always going to be good practice then to regularly review the arrangement and make sure that it's still working for both parties. As we know, the employee cannot make a further application for a 12-month period. Now, refusing the request. This is the one that tends to be the more difficult situation, because people will struggle to say, well, I don't know why I want to say no, but I don't want to accept necessarily the flexible working request. Now, it's vital that that flexible working request refusal complies with prescribed statutory grounds. Now, there are 8 business grounds for refusing a flexible working application. Firstly, the burden of additional costs. So it could be that you have to buy certain equipment, or somebody's proposing an arrangement whereby they will job share. So you need to employ somebody else to come in and take up part of the role that's not going to be carried out, or the hours that aren't going to be carried out. And therefore there could be a burden of additional cost that you might want to say, no, we're not able to accommodate that. Detrimental effect on the ability to meet customer demand. It could be that, for example, the majority of your calls come during a certain time of the day, and that person's required to take, for example, sales calls, but they want to change their hours of work, and it means that there won't be enough people manning the phones. That might be a detrimental effect on ability to meet customer demand. Inability to reorganise work amongst existing staff. If they're saying they want to reduce, they're part of a team and they want to reduce their hours, it might well be that you can say, well, actually, we have others who are completely working to capacity and we're unable to reorganise the work amongst them. That could be your reason. Inability to recruit additional staff. Let's say you've got somebody who works 5 days and wants to go down to 4, and their proposal as to how you will accommodate it is that you employ somebody 1 day a week. Well, it may be that you couldn't possibly engage somebody to work 1 day a week, and it'd be very hard for you to do that, and therefore you could use that as a ground. Detrimental impact on quality. Goes without saying what that may mean. If you haven't got enough people doing the job, it may well be that the standards of service or quality of the work that you're doing declines. And again, detrimental impact on performance is the same sort of explanation. Insufficiency of work during the periods the employee proposes to work. Again, it could be that they're looking to have certain times which do not suit the peak times of your business. And again, you can refuse on that basis. And then the final one is planned structural changes. So it could be that at management level, you're aware of changes that are going to be happening in the business. And if you were to accept that flexible working application, it would be detrimental to the business itself. So again, that's another reason. Appeals. The legislation does not expressly require an employer to allow you, or the employee, to appeal against the rejection of their flexible working request. The code suggests that employees should be allowed to do so. And if you're going to be considered to have acted reasonably in dealing with somebody's request, then it goes without saying really that they should be offered the right of appeal. We know it goes to the heart of the ACAS code, and you'd expect therefore that it would flow into this type of arrangement where an employee is asking to change their hours and they've been refused. My view is it's an essential part of dealing with the flexible working request in a reasonable manner. There are no prescribed grounds of appeal, so an employee can appeal either on the decision itself or the application and the reasons relied on. If they do appeal, then we should require them to put their appeal in writing and date it and set out the grounds of the appeal. The appeal meeting, again, will need to follow the same sort of format that you applied to the original hearing. Employees should have the right of accompaniment. Where possible, the appeal meeting should be conducted by a more senior manager. So thinking of the process in a bit like a disciplinary or a grievance type process, you'd want somebody more senior to be dealing with the appeal. Appeal decision should be, the employee should be informed in writing of what the decision is as soon as possible, and the fact that it effectively completes the internal process. If the appeal is upheld, the employee should be advised of their new working arrangements. You'll need to issue a Section 4 statement, details of any trial period if that's appropriate, an explanation to the changes to their contract, and the date, of course, that the new working pattern will commence. They will need to be advised, of course, that they're only entitled to make another application after a 12-month period, and what is agreed, if it's not a trial period, will be a permanent change to their terms and conditions. Flexible working policy, I'm pretty certain you've all got a flexible working policy, but you should have one, and if you do, it needs to explain how employees should make a request and who the request should be made to and what's covered. Include a statement that confirms the employer will consider the request and will only reject it for one of the 8 business grounds. State who can accompany the employee at any meetings, explain what the arrangements are for appeal, and set out the time limits on dealing with requests. Remember that your process needs to be completed within a 3-month period, but also remember that your policy should make reference to the fact that the parties can agree an extension to that if they wish to do so. So make sure your policy says that. Sometimes policies don't. Just have a look at yours and make sure it does. There are a lot of dilemmas around flexible working applications, and if you have several requests at one time, what do? Well, you can look at each request on its own merits and in the business context. It shouldn't be about the most deserving request, and it certainly shouldn't be about favouritism. And unfortunately, that does happen in the workplace, and you tend to end up with a grievance, or you won't retain staff because they move on because of that nepotism. Possibly consider them in the order that they are received. Consider when saying yes, how that will impact on future requests. Because if you were to say yes to that individual and others made their applications and they got a no, think about the impact that that may have. See if all employees can reach a compromise that suits all if you've got a number of employees that are making applications around the same time. Most importantly, ensure that there's no bias in your decisions, or that decisions are based on protected characteristics. Otherwise, you open yourself up to discrimination claims. What if the employee makes the request but doesn't have the requisite service? I've said to you before, they can still make an application informally. Be aware that they, in that situation, can still bring claims for discrimination. So you must still deal with it, I think, in a reasonable way and ensure that any decisions that are made don't expose you to discrimination claims. What do I think the issues are arising from COVID-19? So we know, don't we, that we think we're going to have an influx of flexible working requests. One of the problems we're going to have, I think, is rejecting those applications. I think companies are going to find it much more difficult to say no to employees because of the way that the business grounds are stipulated under statute. So I think as well, because of the way that the government has informed us that we should be working from home, and because we've all been able to work from home so effectively, businesses will find it increasingly difficult to justify why they're saying no. So, for example, we talked about using the additional burden of costs as a reason for saying no. Now, in that situation, we all know, because my business has done it too, they've invested in Zoom. We know, obviously, as well, that the Chamber have invested in Zoom, Teams, other software has all been introduced by our businesses. So we've already met the cost of allowing employees to be able to work remotely. So I think the burden of additional costs in that situation potentially will make it difficult for you to reject any application. Impact on quality or performance. Now, we're all seeing, aren't we, that we're performing, and in a lot of respects people are overperforming working from home because they're able to work more effectively and in a more flexible way, which makes them more productive, and actually they're delivering better. If it's been the case that you are now going to argue and say, well, you can't work from home because it will have an impact on quality or performance, and that employee can point to the last 3 months and how well they've performed, that's going to be quite a difficult thing for a company to say, no, sorry, we're rejecting your application. In addition, of course, the government have said we've got to work from home. So if you've got a situation where employees are making an application and you're literally saying, no, we can't accept that application, one of the things the employee may say is, well, actually, the government's telling me that I should be working from home, so how can you refuse my application? So that's another thing. And it might be that that's a temporary application or it's a permanent application. Plan changes is probably one of the areas where you probably can still say, we're going to reject the application. Whether we like it or not, we're all heading into a really uncertain time. It might be that everything's switching back on, but unfortunately the damage that's been caused by COVID and pipelines going forward in relation to business mean that all businesses are looking at reducing their costs. So if there is a situation where you're currently at management or board level looking at how you're going to reduce costs, what a restructure is going to look at, and you're starting to receive these applications, it may well be the case that you'd be able to reject them on that basis. However, also bear in mind that if you're going to go through a redundancy consultation process and a number of employees are going to say to you, well, actually, we'd like to propose this as a group to avoid the redundancies, we'll work part-time, we'll work from home, etc., to reduce cost. Again, it might be quite difficult. You'll need to just factor that in as you're going through those types of processes. What if roles can't be undertaken remotely? So that's the key question again that I've been asked before. Well, hold on, all this home working is going on and everyone says they're moving towards home working, but actually I've got people who can't carry out their work remotely. Remember, right back at the beginning, if people couldn't do that, they had to go to work, and you could require them to go to work, unless of course they had to shield or there were other situations such as they've got COVID symptoms. So in that respect, there will still be the right for you to say, I'm sorry that you can't work from home because yours is one of the roles that has to be physically carried out in the workplace in order to refuse those applications. In addition, depending on what happens after full release of restrictions and lockdown, it could be that you have a massive surge in business. So I'm thinking really about property. We're hearing about our local estate agents who are all absolutely rammed at the moment, and everything's gone mad in the property market, and they've not just got their staff back, they've got staff doing overtime, etc., etc. So it could be that when somebody makes that application, you have to say no because we physically need you and this is the reason why. You'll still have those 8 business grounds to be able to rely on in saying no to the individual. So what are the consequences of getting it wrong? So the employee can go off to the tribunal. If you fail to deal with their application in a reasonable manner and you fail to notify them of the decision of their application within the decision period, if you haven't agreed an extension. So those are the 2 ways that the employee can go off to the tribunal. If you fail to rely on one of the statutory grounds, that's another reason why they can dispute the decision that you've raised and take you to tribunal. If it's been based on incorrect facts is another reason. If you've treated the application as being withdrawn when the grounds entitling you to do so have not been met, then in those situations as well, the employee can take you off to the tribunal. Now, importantly, because you're running your business and only you can really make a decision about whether the arrangement that's being proposed is something that you can accommodate, the tribunal cannot question your commercial rationale or the business reasons for you saying no. The tribunal's role, therefore, will be to review the procedure that you followed, consider whether you've taken the request seriously, so make sure you've got lots of notes of the meetings and lots of notes to support your decision. Consider whether the decision was based on the correct facts, and consider whether the reason given falls within the permitted grounds. So that's the 8 grounds that we're talking about there. Now, where the tribunal finds a claim well-founded, you must make a declaration to that effect. So you'll have a declaration against the company, and they may make either or both of the following: an order for reconsideration of the request. If it does this, the date of the tribunal's order will be treated as the date of the request, and therefore the 3-month period will then follow. An award of compensation to be paid by the employer to the employee of such amount as the tribunal considers just and equitable, up to a maximum of 8 weeks' pay. Now, you might think, oh, actually, therefore, the sanctions for getting it wrong aren't too bad. There's only 8 weeks pay as a maximum. We might have to reconsider the decision, but actually we can, it's worthwhile taking the risk. It isn't, because very often what will happen is that alongside that claim, in terms of your failure to deal with their statutory right in relation to flexible working, will be a discrimination claim. And the discrimination claim is the area where you're most at risk of substantial compensation being awarded against you. So if a request comes from an individual who has one of the 9 protected characteristics covered under the Equality Act, a refusal could land that employer with a discrimination claim. I flagged this now because obviously there are a number of individuals who've been shielding, may well have disabilities, may have conditions that may amount to a disability under the Equality Act, and who are now going to think about coming back to work and might make that application with respect to home working. Now, some people might say, well, actually, I'm going to say no to it, and this is the reason why. If you've got somebody with a condition, you need to start thinking about the impact of the Equality Act and the potential of discrimination claim if you're going to say no. So just an example of a case, Walkinshaw versus John Martin Group. A male vehicle technician applied for flexible working but was turned down. Company had historically granted requests from employees who were female to work part-time or deal with family responsibilities, but when his flexible working request was rejected, the tribunal held that he'd been subjected to direct sex discrimination and awarded him compensation. So this was a male technician. The females in the business had been granted part-time working and to look after, more flexible working to look after children. When he made the application, he was refused, and that was sex discrimination. London Underground versus Edwards. The Court of Appeal, in deciding that a new shift system was potentially indirectly discriminatory, noted that women are more likely than men to be single parents caring for children. This assumption that women have the greater burden of childcare has led to a further assumption, which is that a policy requiring that a job be performed on a full-time basis would have a disproportionate impact on women. Since that decision, it's been open to women whose requests for flexible working are rejected to seek redress through sex discrimination through the Equality Act. Shaw versus CCL Limited. The EAT confirmed that the rejection of a flexible working request which amounted to indirect sex discrimination was also a fundamental breach of contract and that entitled the employee to resign and claim constructive dismissal. Reasonable adjustments. I touched on if you've got individuals who've been shielding, for example, and are going to be thinking about coming back to work. In that situation, if you were to consider the flexible working application, you need to also think about it being a reasonable adjustment. So under the Equality Act, the requirement to make reasonable adjustments may mean altering someone's hours or work location, and this requirement will need to be juggled with any other flexible working requests that could, if refused, result in a claim. When you have individuals that are making an application for flexible working and who have protected characteristics, you have to show that your decision to turn the request down was a proportionate means of achieving a legitimate aim. So how do we avoid discrimination claims? Draw up a policy and stick to your policy. That's one of the first things. Make it clear in your policy that each case is considered on its own merits. So just because somebody else had a yes doesn't mean to say someone else is going to, and each case will turn on its own facts and merits. When you receive the request, have a conversation with managers and the employee about whether or not the proposed arrangement makes commercial sense. If there are competing requests, consider which is most likely to result in a discrimination claim, and be savvy. Think about that and think about protecting the organisation and make the decision based around that. Have regard to reasonable adjustments. Take particular care that you can justify turning down a request when the employee making it has a protected characteristic. Although they say potentially deal with requests on a first come first served basis, if you have individuals with protected characteristics and there could be a risk of discrimination claims, consider approaching those requests in more of a holistic way rather than the first come first served basis. Look into all possibilities before you, hold on, you might have lost me in my back. There we go. Sorry about that, my phone went. Include a review clause in your policy and in order to check the terms and conditions of employment, but look into all possibilities before you take the decision to turn the request down. That's vital. Make notes of every decision that you make, because if it is a matter that's taken to tribunal, those notes will be so important in defending your position when you've got a claim. Home working and agile working. So we're talking about, aren't we, in the main, the potential for flexible working requests to be around some form of home working. Three main types of agile working, which is working exclusively at home, splitting time between the workplace and home, and working from home occasionally. So flexible working requests, as we know, can include this particular request, but of course there are lots of practical issues. Firstly, you need to have a look at your contracts of employment and tailor your contracts to encompass home working. Very often you might take somebody on who's, for example, a field sales advisor who works from home and travels out from home and comes occasionally into the business premises. If you've got somebody who's going to be regularly, either part-time or full-time, working from home, then it's important that their contract of employment encompasses that right for their home to be a location as part of their work. Take measures to protect confidential information and personal data. We all had to, with no real notice, we had a bit of notice, but not a huge amount, had to suddenly start working from home, which meant you had families, different businesses, all working in a different in the same environment, but having different types of confidential information. So you really need to think about what steps and what measures you've taken to protect that confidential information. For example, I'm working here at home, I have files for clients, I have lots of information around, and I need to confirm what steps I've taken to make sure that's all locked away and it's confidential and people don't have access to it. Reviewing the health and safety implications, and I'll have a look at that in a little bit more detail in a second. Identifying if any special equipment is to be used. One of the key areas could be that, for example, if you have an individual who's got a back problem, you've bought a special chair for them in the workplace, but they may not have that chair at home because they don't sit in the same way that they're required to do for hours on end at a desk when they're at home. So have you made arrangements to make sure that either that equipment has been transported to them, or have you made arrangements to purchase the requisite equipment? So that's really important. Identify any planning or insurance arrangements. Obviously, people are working from home and they've got your business property in their home and they're using it to carry out work. That may provoke an insurance issue. Management and supervision. What steps are you going to take to manage what people are doing at home and supervise them and make sure that they're meeting all of their KPIs? And are there any tax consequences? Other issues, people may feel they're losing control or they're unable to manage individuals. Loss of the team culture. You're used to getting together, but obviously with the bringing on of software such as Zoom and Teams, everybody can be in the same place, but they are electronically. Less support for employees, especially those that may have mental health or other conditions. A possible increased need to spend more money on technology. And a lack of motivation for those employees who may feel quite isolated if they are going to be working from home. So, main practical issues. Take additional steps to protect the confidential information, which I've said, and make sure that you're having conversations with your staff about what they're doing with confidential information. Sharpen up your policies, monitoring of communications and all of that sort of stuff, and ensure your contract allows you to monitor communications. Contractually reserve the right, if you need to do so, to recover that equipment and to enter the employee's home to do so. Think about a trial period and maintain contractually the right to revert if it doesn't work. Think about if any training is required. I think the vital thing that's going to happen now, because it looks as if now this is going on for quite a long time, if you haven't done one before, you need to be thinking about a risk assessment to be carried out in relation to the home. And you can send that risk assessment to the employee to complete and work through with you electronically or via a meeting with Zoom. So who has access to the computer? Will the employee's home be left unattended for regular periods? Does the remote system provide for encryption? Does the employee regularly change their passwords? What paper files are kept at home? How will papers be transported? Are there rules on retention of information? What about disposing of information? Because obviously that can be confidential. And what software is the employee using? That risk assessment, as well as the normal risk assessments that should be carried out, in the context of home working, you need to think about doing a stress assessment. There's lots of templates on the HSE website if that would help you if you don't already have a stress assessment. Equipment, making sure it's maintained in good order. Think about lighting, whether the employee's working in a way that they have plenty of light. First aid, what's going to be dealt with in terms of that if there's an accident at home, and a reporting procedure. So even if there has been an accident at home while the employee's working during working hours, you should still be making a note of that from a reporting procedure point of view. Insurance I touched on. Well, there could be an issue there, couldn't there, with insuring that equipment within your employee's home from theft or fire or damage. So again, that could be a conversation that will need to happen if you are going to be agreeing to home working on a more permanent basis. You may have to contribute towards the cost of the insurance. So that's something, again, you might have to factor in. The employee might seek to claim a deduction against tax for household expenses, and there's a certain percentage that you can claim, even if you're an employee. So as a self-employed person, I make a certain claim for the amount of time that I used to work from home, which was obviously much less than it is now. But that obviously is open to the employee to make that type of claim as well in relation to a tax deduction. The employee might want to know what you're going to do about their lighting and heating bills, and cost of business calls and internet. You might have to foot the bill for things like broadband. Finally, just one little point that I'd like to leave you with is really in relation to COVID and the gig economy, which is of course linked into flexible working. We know that companies have for some time now been looking how to engage workers in different ways and much more flexibly, and that's been the trend through the development of the gig economy. I think we're likely to see a lot more cases, as we have with the Deliveroo, with the Uber cases, coming through with people challenging status and challenging what their rights are, connected to all the flexible working trends. So that's just flagged up as a separate thing at the end. And I think that kind of brings everything that I wanted to say to you to an end. But I think I've been watching and we've had quite a few questions flagging up. And I know we had a question, didn't we, before, Olivia, as well, before the webinar.
Yeah, so the first question that's in the chat anyway is the one that we managed to forward on to quite quickly.
Yeah.
So do you want to go through that one?
So that question was, are employers doing enough for females re-menopausal symptoms? Now, this is one area where flexible working probably would be a good opportunity for you to reach agreement with an employee who may be having menopausal symptoms. I can tell you now, sometimes it happens at the same time every day. So it could be that you have an arrangement with the employee that they adjust their hours, or they adjust how they work, or they take a break at a different time. You've got to start thinking more laterally about how you can support workers who are going through the menopause. We had a flurry, if you remember. It was around the time that mental health started to really gain some momentum in terms of businesses taking note of that. Mental health has carried on to grow, as it should do, as a key factor for companies to consider. Less so menopause. I think companies could be doing more, if I'm being really honest, and they could work more closely with employees to allow them to work flexibly so that they can cope with their symptoms.
Thank you. I'm just going to go down the group chat area then and just see what's been going on in there and read out any questions that we've had. So we've had one: if you accept a request in one area of the business, have you then set a precedent for all departments?
No. So every request turns on its own facts, and the fact that you've accepted, you might have employed 20 people, it's your first application and you've said yes to it. If you then, within a very short space of time, or even a long time, had another application, it will turn on its own facts at that time, and your business may have changed and you don't have to accept it. You might have one a few months later and actually it suits the business and you will accept it. So each one turns on its own facts. Where you get some difficulty is if you've got a number of people who are all making applications in the same department, and that tends to be then the difficult one. You've got to work out whether you want to come to an arrangement and meet with all of the staff and they decide how they're going to arrange it between them, or you just do first come first served, unless you've got somebody with a protected characteristic which you might want to override and make the decision for them as a positive rather than a negative.
Okay, thank you. Someone just asked for a quick recap on formal and informal requests.
So informal requests can happen at any time. So it could be that it's somebody who's less than 26 weeks service, so they haven't got the statutory right to make the request, or it could be somebody who has got the 26 weeks but still makes an informal request. So my view, and I've always advised clients of this, is it doesn't matter whether you get an application with somebody that's got less than 26 weeks or more, because you've got the risk of a discrimination claim from somebody with less than 26 weeks, I would still treat it as an application. So you're not going to say to them, well, okay, you've got the statutory right. You will say you don't have the statutory right. However, we will reasonably consider your application and take them through the process. Does that answer the question?
I think so. Yeah, some nodding heads.
Yeah.
Question for me, actually. How do we access the recordings of the webinars? Julie, we'll put them on our YouTube channel. So if you go onto YouTube and type in Herefordshire and Worcestershire Chamber of Commerce, it'll come up. But they are also on our website as well. It does take about 24 to 48 hours for us to get them on there. So just bear with us on that. Next question, not for me, is insurance. Should we still have commercial insurance for equipment in their homes, or should they add this to their own home insurance?
I think you need to speak to your commercial insurer, because ultimately you own that property, but it's in somebody else's property, if that makes sense. And I'm no insurance expert, but in my view, if it's put onto their insurance policy, it's not actually their property. So in the event of a claim, I'm not sure how that would work. I think you need to speak to your commercial provider and get guidance from them as to which is the best way around to do it.
Are we allowed to offer employees money for, say, broadband and utilities, or is this covered in the home working allowance?
You can, absolutely, if you want to do that. It's up to you what arrangements you put in place. As I've said to you, I've flagged up what some of the issues are. Ultimately, it's about agreeing with the staff how you want to facilitate them working from home, and how you are going to agree the costs are going to be met. I think everybody, when we started this, thought this was going to be quite a short-term thing. It's clear it's not going to be, so we need to start thinking about what long-term measures you're going to put in place. Okay, and would you advise having a separate home working policy and flexible working policy, or encompass in the same policy? Separate. Definitely separate.
Okay. Does the employee have any rights if the employer refuses to pay towards broadband, etc.?
It's a difficult one. It's a difficult one, because obviously you could say, well, okay, if you don't want to meet the costs of being at home, then you've got to return to work. But ultimately, you've got all the benefits of them working from home. So I'm not sure. Certainly at present, there'll be nothing in a contract of employment that says you are entitled to be paid for the cost of home band at your home. And therefore, if you fail to pay it, then you would end up with a claim. However, if you had reached agreement and then didn't pay it, you certainly would end up with a claim. I think it's a grey area, and I think the best thing to do is to think about each individual person that might be working from home, how you're going to deal with it. And it might be that you just say there's a blanket amount that we'll contribute to all employees working from home, and that's it.
Okay, thank you. This one is a fairly lengthy one, so bear with me. Someone just wanted to confirm their understanding. In a redundancy situation, if flexible working is suggested by the staff members as a measure to prevent so many people losing their jobs, the flexible working agreement could be discussed and agreed. This would then be considered as an agreed contract amendment, which is separate from contractually forced short-term working, when after 4 weeks of altered hours, a staff member can claim redundancy. Correct?
So if you have somebody who's in a redundancy process and you're consulting with them, or you have a group of people in a redundancy process and you're consulting with them, and they say to you, right, well, we're all willing to adjust our hours so that you can actually accommodate all of us without anybody being made redundant, that will be an agreement through consultation to change their terms and conditions. It is permanently in place and moves forward. It won't be the situation where you've got somebody who has been placed on short-time working and then they can make their application for redundancy. Have you got somebody that is on short-time working and could make that application?
I think they've summarised it sort of at the end. They said, could we suggest this to staff as a potential way to avoid some redundancies, or does it have to be initiated by the staff?
No, you can suggest that if you wanted to do so. You can say, look, we're open to, I've just been going through that with actually a client that I'm advising at the moment on the redundancy process, and saying, say to the staff, we're open to your suggestions around how we can avoid the redundancy. We want to meaningfully consult with you, and that might include you putting forward alternatives such as part-time working or other arrangements. So absolutely, yeah.
Okay, thank you. I think this is our last question, so this will be the last opportunity for anyone else that's got any other questions to quickly pop them in the group chat. But the last one we've got at the moment is, we are considering trialling part-week home working for office staff while maintaining core days and hours office cover. If not a permanent home working arrangement, are we obliged to pro-rata contributions towards costs such as broadband upgrades or any other legitimate home working costs?
Okay, so you're not obliged to, because ultimately, you've got to reach agreement with the staff. So it's not that it automatically follows that you've got to pay it. I think you're going to be criticised, or the employees are going to be criticised, if it's coming from you that you want to introduce the part week home working, but you're not willing to contribute to their costs. I think that would be an issue for you. But you're not necessarily obliged. This is an issue for you to agree with the staff.
Okay. Has anybody else got any other questions they want to raise to Sally while we've got her here? Just give everyone, I'll just give everyone a couple of minutes, just because I understand it can take a minute or two to type them up. So whilst we might have another couple of questions, I'm just going to run over a couple of webinars that I think might be useful for you. Next week with Hewitt Recruitment on the 8th from 12 until 1. We've got a webinar that's going to be about recruitment and looking at the new normal of what recruitment is going to look like going forward. And on the 15th, which is the week after, again on Wednesday in the afternoon, we've got a half-day training workshop, which is going to be based around dealing with difficult conversations and how to handle those using video conferencing. So how do we do things via Zoom? How do we handle and have those difficult conversations via Teams? And all that. So if you are interested in either of those, then please let myself or my colleague Yasmin know, and we will book you on. Just going back to the chat, can't see any other questions. Sally and I are going to agree another webinar, which is going to be based around redundancies. So after you've all left, we're going to agree a date, and we will of course let you know as soon as that is ready to be booked onto. Likewise, if you've got any topics that you would like us to arrange with Sally going forward, then again, please let us know. We want your feedback and we want to be able to help as much as possible. But finally, I think everyone's just saying thank you, Sally. So yeah, I reiterate that. Thank you very much. Thanks all for joining, and look forward to seeing you again soon. Thanks all.